It's time to go on the record with WRAL News.
Thanks so much for joining us for On the Record. I'm Lena Tillett. You may not have seen it, but this month, a crucial hearing with implications for hundreds of death row inmates statewide happened in a Johnston County courtroom. The case explores an aspect of the criminal justice system that gets to the very heart of equal justice under the law, how a jury reaches a verdict, and how it decides to sentence people in North Carolina. Take just 2 cases in Johnston County in the last 3 decades, and a forewarning for you, the details of these cases are difficult to hear. In November of 2018, 71-year-old Kathy Thomas went missing. It would be weeks later before authorities searched the backyard of a man's home and found her body buried in a shallow grave. 50-year-old Kenneth Wayne Lamb, a 3-time convicted rapist, was arrested. He'd had a brief relationship with her. Lamb initially was charged with first-degree murder for the crime, with the possibility of facing the death penalty. In October of last year, Lamb was found guilty by a Johnston County jury of second-degree murder, a lesser charge, and he received a life sentence. In February of 2007, about a decade earlier, Anthony Searles was a senior at Smithfield Selma High. The 18-year-old was with his family inside a Selma home when 2 men attempted to rob them. Hassan Bacote, who you see here, was one of them, and he shot Searles as he tried to run away. He later died. 20-year-old Bacote was charged with first-degree murder, though there was no evidence the shooting was premeditated, and he too faced the death penalty. In 2009, a Johnston County jury convicted Bacote of first-degree murder and sentenced him to death. 2 heinous crimes, 2 very different outcomes. This is Hassan Bacote today, facing the fight of his life now at 37. He's challenging his death row sentence through what's called the Racial Justice Act, or RJA. This unique state law, which passed in 2009 and was repealed by state Republican lawmakers a few years later, allows people on death row to challenge their sentences if they can show that racial bias played a factor in their cases.
The General Assembly enacted this unique law to really rid the state from the harm of what had been a history of racial discrimination that dates back decades, if not centuries. What this evidence will show is that black citizens throughout the state of North Carolina are excused from jury service at levels that are twice that of their white neighbors. That in Johnston County, and in this case in particular, black citizens were excused at 3 times, triple the rate of their white neighbors.
Defendant's sentence of death for this serious crime was not sought or obtained on the basis of race, and we will ask you to uphold the jury's verdict and sentence in this matter.
Tonight, Henderson Hill, who you just heard from there, part of the legal team for Bacote, is joining me in studio. Mr. Hill is a senior counsel for the ACLU's Capital Punishment Project. And also joining us via Zoom is Samuel Summers, a psychology professor at Tufts University. Professor Summers provided key testimony on the science of racial and implicit bias in jury selection. Thanks to both of you so much for joining, especially to you, Mr. Hill, for being here in person. In your opening, you talked about the historic opportunity of the Racial Justice Act. What is it trying to accomplish in this state?
Well, it's answering the call that the United States Supreme Court left in 1987 in a case out of Georgia, Warren McCleskey versus Georgia. There, Professor Baldus presented evidence of overwhelming discrimination, racial disparities in the application of the death penalty. The court didn't dispute the legitimacy of the study, the accuracy, the methodology of the study. It said, well, that's not the business of the federal courts. That's the business of the state legislatures, the state courts. And in 2009, North Carolina's General Assembly answered the call. They passed the Racial Justice Act, which specifically licensed the admission of scientific evidence, statistical evidence of race discrimination. That's a first. nationally. And it's important. It's an important piece of legislation because it brings criminal justice in the same space that public health, education, employment, every other sector of life uses science, uses statistics. So we're not left with just the anecdotal sense from lawyers that race plays a part in the criminal justice system. We can rely on science.
You know, one of the things that you said that I thought was interesting is that discrimination in the criminal justice system is not a fluke, it's not confounding, but there is supporting evidence to show that this is something that's systematic. What are you trying to show specifically in Bacote's case?
Well, in your lead-in, you sampled a little bit about what Professor Smith demonstrated. In the 40 years in the modern death penalty in Johnston County, 7 black men have gone to trial capitally. All 7 of them received the death penalty. In that same space of time, 11 white folks have gone to trial. 6 of them got life, 5 the death penalty. So a white person has a better than even chance of getting a life verdict in Johnston County. A black man doesn't stand a chance. And that's replicated in counties across the state. We actually heard testimony from Brian Stevenson that it's a reality in much of the death belt. And it's not a mistake, it's not a fluke that the death penalty is most aggressively pursued in the old states of the Confederacy. The link between the period of enslavement, the Black Codes, Jim Crow, and the modern death penalty is undeniable. And Professor Stevenson has devoted his professional life to understanding that legacy and also amplifying that and bringing that into the public space. He's probably one of the most respected public intellectuals in the country, and he's done a remarkable job of bringing that history into the policy discussions of our day.
And just to be clear for our viewers, you're not trying to overturn the conviction. What you're trying to do is allow it to be a life sentence instead of death row.
In this motion, that's exactly right. But in this particular case, my client, Hassan Bacote, actually has his direct appeal right still pending. His case has not been on direct review. So he does have the opportunity in that proceeding to challenge the underlying conviction. But that's not what this motion is about. That's not what this litigation was about.
I want to bring Professor Summers in. So the testimony came from data analysts, social scientists, psychologists, historians. Professor Summers, you had some of the most fascinating testimony, really, where you were describing the role that implicit bias plays in our world and also in jury selection. Why is implicit bias critical here?
Well, I think you're right. I played one small part in the presentation from a variety of experts, but what I was speaking to is this question of bias and the psychology of how we see the world around us. And your question about implicit bias or unconscious forms of bias is really important, because I think if you ask individuals in life more generally, to what degree have you been influenced by someone's race or by other forms of bias in the decisions that you make, a lot of times people will tell you, and they will earnestly mean this, that they weren't. They didn't think about race at all. The decisions that were made in this instance had nothing to do with race. I was going based on the facts of the case or the resume in front of me for this job search or whatever the question might be. We know from the science of implicit bias, unconscious bias, the psychology of bias and racism more generally, that often race influences the way we see the world and the decisions that we make, even outside of our conscious awareness. You can't take at face value every time someone says, no, race played no role here at all. That doesn't rule out the possibility that race may very well have played an important role in the decision.
And you really talk deeply about the role that implicit bias plays in juries specifically. I want to first play a soundbite from an experiment that you were involved in where you were looking at implicit bias and people's direct responses to some of the questions about Black people and white people. Let's take a listen.
A lot of people who take the test will be quicker to pair white faces and pleasant words together, Black faces and unpleasant words together. They're faster at that. That seems an easier, quicker task for them to complete than to do it the other way around, to associate white faces with unpleasant, black faces with pleasant. That tends to be slower for a lot of participants, and that's one way that researchers would measure implicit bias in a study.
Why does that matter when it comes to jury selection, Professor Summers?
It matters for the legal system more generally because there's nothing magical that happens. There's no magical switch that we can flip when someone walks into a courthouse to become a juror or even to take an oath and be an attorney or a judge. There's no magical switch to flip that makes us free from all the biases that influence us as human beings more generally. So it's important because we have, in the society in which we live, and the historians who testified a few weeks ago in the hearing, I think demonstrated this very compellingly, associations between, in this case, race and criminality, race and different negative stereotypes. And those associations can be so ingrained in a society and in individuals that they come out in ways that are even life and death, even in decisions made during jury selection and decisions made by juries. Again, the basic human psychology of how we see the world, we bring that with us into the courthouse. It plays itself out in trials, even in capital trials involving death penalty decisions.
And this, of course, is why it's so important who is allowed on juries and who is not. We're going to get into that. Such fascinating implications for that. Much more on this historic Racial Justice Act hearing coming up. Stay with us. Welcome back. We are discussing the Racial Justice Act hearing that's happening in Johnston County that could take a man off death row. Mr. Hill, again, Bacote's lead attorney in this case. Can you talk about the significance of the jury, specifically in Bacote's case? There were 10 white jurors and 2 black jurors who ultimately convicted him of first-degree murder and sentenced him to death. Talk about the selection process to get that jury.
Well, race discrimination, if it's not addressed, simply changes forms. And in Mr. Bacote's case, there were 2 black citizens on the jury. What that suggests and what that represents is the application of sort of a quota system for the jury service. Instead of putting citizens on an equal basis when they present themselves in response to a summons, these old stereotypes, presumptions about black citizens that present themselves for jury service comes in. And what was shocking in this litigation was to actually get the notes of prosecutors and see the descriptions, first of all, that they were preoccupied with race. You know, this person went to this HBCU. This person is a member of the NAACP and talks about that membership as if that is an anti-state association. To talk about white jurors who, that woman has a child by a black man. It's this preoccupation with race that dates back to the earliest parts of the 20th century, just after after Reconstruction, the beginning of the black codes, when black people didn't have the full franchise. You couldn't vote, and if you're not registered to vote, you're not in the jury pool. So this notion that jury service, this important aspect of democracy, was not to be extended to black people is something that carried throughout most of the 20th century until the Voting Rights Act. One of the important observations that Justice Kavanaugh made in a 2019 case is this discrimination against black jurors is a matter of history and math. There are only 12 seats in the box. Prosecutors get the right to excuse in North Carolina 14. It didn't used to be true. In 1977, they doubled, the General Assembly doubled the number of excuses that prosecutors would be entitled to. With that, as Justice Kavanaugh notes, you can control the complexion of the jury. And that's what happens in North Carolina time and time again. You get either all white jurors or nearly all white jurors. And that distorts the deliberative process of the jurors.
And what's the assumption here? That black jurors would be more sympathetic toward a black defendant?
for the black defendant, towards his life experiences. Much of what happens in a sentencing phase is a description of childhood abuse, neglect, poverty, mental health issues. Well, if you don't see the theory is of prosecutors, if they look and see the defendant and can acknowledge people in their family and their social circle and their neighborhood, they might be more sympathetic. The flip side of that is there's an assumption that if you come from the other side of the tracks, you're not going to be as receptive to that kind of evidence. And it's that sort of strategic advantage that prosecutors think they're going for that distorts the process.
For white defendants, is that happening as well? Are prosecutors trying to get more black jurors on the jury?
It's very strange. There were, as we did the statewide study, there are 176 cases. Yeah, interestingly, in those cases where there was a white defendant, for example, in Cumberland County at Fort Bragg, there were some racist killings by a couple of white soldiers. Blacks were not discriminated. Blacks were welcomed onto the jury. The numbers were just phenomenal. You know, the reversal of the racial dynamics there. So it is a sort of gamesmanship that prosecutors are playing. And this is something that literally has been going on for well over 100 years.
Professor Summers, you know, many of the prosecutors in these cases said that they did not base their jury selection on race. What does the data say? And do you think they're being dishonest?
I'm not going to sit here and tell you that necessitates the conclusion that they're being dishonest. I think in many instances, they might genuinely believe that. Now, there are some cases, and Henderson gave some examples of pretty clear statements regarding, well, this person's a member of the NAACP, and therefore I don't think they'll be, and that's clearly a proxy for race. But again, I think even when race does have an influence, it's not always something that people want to own up to or are fully conscious and aware of. So I'm not suggesting that every time a prosecuting attorney has said race played no role in this case whatsoever, that it means they're a liar. They very likely in many instances truly believe they're going just based on the kinds of criteria they're allowed to consider. The research indicates, however, that self-report, like our own explanation for why we do what we do, is notoriously unreliable.
So, Professor Summers, what does the research tell us about the influence of race on cases like this, specifically on sentencing?
Sure. Well, racial composition of a jury has been found to really matter. It makes a big difference. I mean, it makes a difference constitutionally, first and foremost, right? We all, as citizens of the United States, have a right to serve on juries. And so when you see jury selection exclusions being based on race, we're depriving certain citizens of that constitutional right to play a part in the system, an important part in the system. But it is also the case that when you have juries that are all white or predominantly white, or the more white those juries become in terms of composition, research has indicated juries like that tend to be more likely to convict, tend to be, in cases with a black defendant, more likely to come back with a sentence of death in capital cases. So it can make a difference in terms of final decisions. There's research that suggests that diverse juries can be better deliberating groups and consider a wider range of information, and that can be really important. And finally, another factor here is that just citizens in the country more generally have a greater faith in the legitimacy of the legal system when they see that it's representative. So when we as Americans see juries that don't look like representative compositions of America, the United States that we know, it undermines our faith in the system. It undermines our faith in justice. I think that's another important research point.
Mr. Hill, final question to you. We only have a few seconds left here. If you're successful with this case, if you're able to prove statistically through all these anecdotes, through all of this testimony, that the racial bias did play a role here, what might this mean for the 100 plus other death row inmates in this state?
Well, we had 2 weeks of evidence. We had some of the most extraordinarily credentialed experts in the relevant field. Professor Summers is reflective of that. We've created a record that could be relied upon. You know, at one point, I think it was at the fourth statistical expert to testify, that expert said, well, now we're moving into really high-level statistics here. This is a graduate course. Oh, well, when you put that kind of energy and resources to make a record, that's a record that can be available to the 100 other petitioners. There's no reason to duplicate the presentation of many of these experts. The interests are identical. And so we've got a record that we think would be efficient and effective and productive for the other petitioners. Certainly those defendants, those lawyers, the court will have to make independent judgments about how to make use of this record. But we believe that it has been a comprehensive record, perhaps the most comprehensive record on the Racial Justice Act in the 14 years that we've been litigating this in the state.
I tell you, the testimony has been fascinating. Mr. Hill, Professor Summers, thank you so much for your time, and best of luck to you in the future.
Thank you.
Coming up, sports betting. It's here just in time for March Madness. Next, how the industry is doing so far and how this could lead to more gambling in North Carolina. Welcome back. Sports betting is live in North Carolina, as you've no doubt heard from the never-ending string of commercials. Just in time for March Madness, of course. Brian Murphy, WRAL Sports investigative reporter, is joining us now to discuss the rollout. Yes, we have all seen the commercials. They're in all of my podcasts now, by the way, too. So we've had about a couple weeks of sports betting. How's it going?
Well, by all accounts, the rollout went smoothly. There were 8 operators that were licensed to take bets on the first day, and all 8 have been taking bets. We don't know how many bets have been placed or how much money's been wagered, but members of the North Carolina Lottery Commission said earlier this week there's been a lot of bets placed. More specific numbers could come as soon as next week, and I think North Carolina's totals are going to be way higher than they were projected to be.
So what do operators have to report here?
They'll have to report the amount taken in. They'll have to report the amount they paid out in winnings. They'll have to pay an 18% tax, and that money will go to athletic departments at 13 UNC systems, and not UNC or NC State, however. And it'll also go to several youth sports programs, and about $2 million will go to gambling addiction and treatment programs. So North Carolina is certainly turning into a gambling state. The lottery announced a record in January for scratch-off tickets at its new digital instance, is producing about 4 times as much revenue as was forecast.
You were saying off camera, anecdotally, you are hearing that there is high participation with sports betting specifically in the state.
Yeah, they joked during the call yesterday, or they joked during the call that, there have been a lot of wagers placed. And if you just hear the buzz that I'm hearing from a lot of people that I talk to, but even just friends and neighbors that I didn't think would be participating in this, they all seem to be at least involved, at least testing out the free gambling sites.
So what does this mean for potentially legalizing casinos, more gambling in the state?
State lawmakers are already considering legalizing video lottery terminals, and sometimes called sweepstakes or video gaming terminals. The state's been unsuccessful in getting rid of these illegal machines, so now they're considering regulating them and taxing them. If that sounds familiar, that's what they did with sports gambling. Casinos is another topic that comes up a bunch. I don't think we're going to see casinos on the agenda this year from lawmakers.
Do we have any idea how much people lost by not betting on NC State to win the ACC tournament?
Well, if you had just taken NC State game after game after game, you would have made a lot of money. Judging from some of the responses that we've gotten from the operators, most people were betting on the Tar Heels.
Well, we'll see what happens in the tournament. Brian, thank you so much. If you have something to say about tonight's discussion, you can email us on the record at WRAL.com. Thanks so much for joining us. Have a good night.